Next case on the docket is GARMONT versus State.
May it please the court. My name is Thomas Cushman. I represent Michael GARMONT. Mr. GARMONT was charged in the trial court with dealing in stolen property, grand theft, and solicitation to commit grand theft. The subject of those charges were some junk airplanes stored on property he owned on US 1 north of St. Augustine near the airport.
Let me ask you about your reference to junk airplanes. The trial court after a restitution hearing found that these junk airplanes or their parts were worth in excess of $200,000.
Yes, sir.
Your brief almost seems to ask us to assume that those parts were worth a couple $100. Since the trial judge made a finding that these parts were worth in excess of a couple $100,000, and since that decision was not appealed and became final, shouldn't we as a court assume that those parts were worth in excess of a couple $100,000?
Well, the fact that the photographs of the airplanes and the circumstances were included in the record on appeal, I think you could look at them and say there's clearly something wrong. Yes, you're right, the court is entitled to a presumption of correctness. But the reason we're attacking by 3850 is the inadequate representation, the ineffective representation from the defense in the original case.
But the first counsel had nothing to do with the finding of $200,000, did he?
Not the amount, no, sir. On the other hand, without the ineffective assistance provided by trial counsel, we'd have never gotten to the restitution issue.
But you're not claiming ineffective counsel at the restitution hearing, correct?
No, sir, we didn't.
And no appeal was taken of that judgment,
That's correct.
One of your arguments is that counsel was inadequate because they had this defense about the landlord's lien that they didn't bring forward.
Correct.
No dispute the amount of unpaid rent was far less than $200,000, right?
Far less, yes, sir.
If we assume or take as given what the trial court found and was not appealed, that there was $206,000 worth of materials taken, wouldn't that destroy the landlord's lien anyway, or the defense of a landlord's lien, since it was so much in excess of what was?
No, sir, I don't think so, for two reasons. First of all, what Garmont admitted taking and what was found on the property then I think the issue would have been a jury question of what the value of the property was. Second of all, Garmont was never advised of the claim of right defense. The lawyer at the hearing said there is no such thing as a landlord's lien. Clearly he had done no research. Clearly he didn't know what the law was. The claim of lien defense does not have to be, especially in a 3850 situation, it doesn't have to be completely proven. The issue is, did the defendant have the intent to deprive the owner of the property? And if the property is taken under the claim of right, under the belief that he had a right to take the property, and whatever the court found was to the value where he sold it, he got less than $300 for the property he supposedly stolen. On the other hand, he had a claim of right, but that's the other place where the lawyer simply would not listen. Garmont admitted to his lawyer, yes, I took the airplane wing, yes, I sold it, I got $200 and some for it, and in the end, that's all he did. The lawyer took the attitude, that's theft. Well, it's not theft if there's no intent to deprive. And there's a long line of cases, more than 100 years old, saying without the intent, there is no theft. Without the theft, there can't be the grand theft. Without the theft, there can't be the dealing in stolen property, nor can there be the offense of solicitation to commit grand theft. Now,
so the defense would be he had some right to take the property as the landlord by self-help without regard to any court proceedings, any judgment, any right order from the court telling him he could do it? Is
yes,
that
sir.
The defense?
Yes, sir. He had the claim of right. We've never said that this would have perfected the lien in the proper way. Frankly, I don't know if it would
Would it
or
have
not.
been a legal defense?
Yes, sir, it would.
Why would it be a legal defense? What's the basis on which a landlord would have any right to self-help?
It's a lien for rent, and he has a right to perfect that lien by taking certain property. What Garmont sold, what he was charged with, was the sale at less scrap metal of half a wing.
It was the sale of $206,000 worth of parts, apparently, based on what was ultimately decided.
But there was a difference in what supposedly was taken and what was sold. I mean, there's no real indication that anything was taken, but they couldn't find it on that property, which is like a jungle. I mean, that's clear from the testimony.
Does the landlord lien require that there be some type of notice? In other words, the landlord tell the tenant, I removed your items because you're behind in rent and I will return them upon you paying rent? Or does it just allow a landlord to walk on the property and take the tenant's property and not tell them and sell it and not worry about it?
I don't think that's the proper way to enforce the lien,
well,
but that's not really the issue.
Did your client, was there any evidence that your client ever indicated to his attorney that he gave notice to the tenant that I removed these items because you're behind in rent?
Well, the client went to the lawyer for the legal advice that he didn't get.
Right, but was there any testimony, any evidence, anything to suggest that your client gave the tenant notice that I am taking these parts because you're behind in rent, or that he indicated to his attorney that fact?
Not that I know of, not that I recall from the record.
Well, without that evidence, is that a viable defense?
Yes, sir, I think it is. It's not a question of is the claim correct. The question is, did he have a valid claim? And clearly he was owed rent. He had a valid claim. And the cases talk about if you have the intent to make yourself whole as opposed to a theft, it's not a theft. And without that, there can be no theft.
Well, the alleged ineffectiveness is that the trial counsel didn't know that there were landlord liens and therefore didn't tell his client about landlord liens.
No, sir, actually that's not correct. The lawyer was aware of the unpaid rent. He said he had contacted the person who owned the property, Mr. Goldman. He knew about that, and he said he wrote a letter to pester him. No question about enforcing a lien or claiming a lien. Garmont went to the lawyer for legal advice.
And the ineffectiveness was what?
Sir?
The ineffectiveness was what?
Failure to investigate. He didn't know the condition, or actually he did know the condition, but raised no question about it.
Failure to investigate
the condition of the property, what actually took place, the fact that Garmont admitted to taking one half of one wing and selling it over at Les Auto Parts. The failure to do the research, the lawyer clearly didn't know that Garmont couldn't be charged, or at least could be convicted of dealing in stolen property and theft when he took the property. This court's...
And why would that be?
This court's...
Because of the landlord's lien?
No, sir. Just an individual cannot be charged with dealing in stolen property when he's the one who took it. This court did a case called Camp, which was affirmed by the Supreme Court, saying that's essentially the law. It recites that this dealing in stolen property is the anti-fencing law. If the person admits that he took it, and Garmont always did, then there's no question that he could not be convicted of dealing in stolen property.
Didn't he plead the grand theft?
He pled the grand theft, that's correct, sir. They dropped it as if he were getting some great deal. when in fact the statute, he couldn't have pled to both of them anyway, couldn't have been adjudicated, and couldn't have been found guilty of both of them.
Mr. Cushman, I got the impression from reading your brief that your client's chief complaint here is that he entered into a deal, he thought that he was going to get socked with restitution in a fairly nominal amount, and he ended up getting whacked with a $200,000 restitution judgment. Is that not his
Well, he
chief
certainly didn't
complaint?
care for the judgment of $200,000.
I'm sorry?
He certainly didn't care for it, but on the other hand, neither does he care for the probation and the restrictions on his life.
Okay, but getting back to my question, maybe you don't want to be pinned down here, but wasn't that his chief complaint, that he thought he was going to have a nominal amount of restitution, and based on his discussions with his lawyer and everything, and he ended up getting whacked for a couple of $100,000?
Well, he did get whacked very heavily, which of course played a part in the decision to question the whole thing.
And he got a bad result.
He did.
At the restitution hearing, and the bad result was that he got, essentially back to the beginning, your opening remarks here, is that he got hit for a $200,000 judgment for disposing of some junk, really, right?
Yes, sir, scrap metal.
Right.
And so, yes, we are concerned, but on the other hand,
How can we blame all that, though, on lawyer number one?
well, lawyer number one did no investigation in that either. His strategy was lay low. They won't come up with anything. Mm-hmm. Obviously, that didn't work, and
I'm wondering what investigation a criminal lawyer is expected to do about the value of the property. Is he supposed to go out and actually look at it? Does that, do criminal lawyers do that in the real
yes,
world?
Yes, sir, they do.
They do. They go out and they look at the property, huh?
Good ones do. Mm-hmm. Yes, sir. They go out and look at the property. Besides that,
right. But competent lawyers don't necessarily have to do that. You go to a restitution hearing, victim's got to testify about value. Maybe you get an expert. Maybe your client is capable of giving some testimony that bears on that, and you go and you handle the restitution hearing. From what his client told him, it was junk, right? It was valueless stuff.
Well, it's pretty obvious it's junk, too. Like I say, it's been out there for a long time. Everybody up in that part of the country knows it's out there and knows it's junk. There's trees growing through the fuselage. So it's not just the restitution hearing, it's the entire thing, because if he hadn't pled, if he got good advice in the first place, he wouldn't have pled.
But he had a bad result at an evidentiary hearing that the lawyer didn't even participate in, right?
Well, he did it first. There was two hearings, at least two. That's not part of the record, or at least the second part of the record does not include the first hearing. But, yeah, he got a bad result, but the reason he was getting a bad result was the failure to advise him about
whose responsibility was the bad result at the restitution hearing? Lawyer one, lawyer two, a combination of both?
I would say lawyer one. I'd like to reserve the rest of my time for you. Right. Thank you.
Good morning. May it please the court, counsel. My name is Jeffrey Casey. I represent the state of Florida. Mr. Garmont had the opportunity at the 3850 hearing to testify that he believed that he had a right to take these airplane parts and sell them. He didn't do that. He had counsel, this counsel, who knew all about the claim of right claim that would be made in this court, or clearly would be made as part of the 3850. Appellant did not.
But I guess what Mr. Cushman is saying is that one of the fundamental responsibilities of a lawyer is to properly advise the client about what the law is.
Absolutely.
As it relates to a given set of facts, so that the client can, even if the defense is not a winner, if it's a defense that could be asserted and it may bear on the client's decision to enter a plea, that the client's entitled to hear that advice, right?
That's all true, Judge Torpey. Right. And the fact in this case that's missing from the establishment of even the presentation of that defense is that Mr. Garmont did not actually believe that he had a right to take these airplane parts and sell them. And that's what's missing from the claim of right defense, is that he had to actually believe that he had them, that either they were his. The example I think is used in the olden days is the cow that crosses the creek. That's my cow. No, it isn't. That comes up in those Replevin cases. In this situation, he never actually believed that those parts were his, or that he had a greater right to possess and dispose of those parts than the tenant. He never testified to that. He had plenty of opportunity to do so.
Maybe if his lawyer would have told him about this theoretical defense, maybe his belief might have changed.
Well, presumably Mr. Cushman told him about this theoretical defense, and that at the hearing, when Mr. Garmont testified at the 3850 hearing, he could have testified then, I always believed that I had a right to dispose of these. He never did so. And I think the reason he didn't do so is because it wouldn't have been true. He never believed it. He told Mr. Alexander at the beginning, this is what I'm charged with. Alexander looked at the paperwork. He read everything. He explained to him the charges, the penalty ranges, what they encountered, what they were all about. He explained to him using what he said was the bubblegum example of dealing in stolen property. I would like to address the Camp case. Camp talks in terms of stealing checks, but checks have no value unless they're negotiated. The court also said, yes, that's true. If you steal checks and you negotiate them, that's kind of part of one continuous theft. But if you sell the checks to someone else, that's dealing in stolen property. And that is why Camp is inapplicable here, because that's exactly what Mr. Garmont did. He took the property, he sold it to someone else. Mr. Alexander worked out, I think, an excellent outcome for Mr. Garmont. I was in private practice for 13 years. This is the kind of thing that I would recommend to my clients. Clearly, he got an opportunity to choose between a second-degree felony, which he did, deal in stolen property, or a third-degree felony, which he did, that is, steal the parts. Mr. Alexander worked out an opportunity for him to plead to the lower, and it reduced his potential exposure by 10 years, should he fail to live up to the terms of probation. I think that's an excellent outcome. Mr. Alexander had all the information. He passed that information on to Mr. Garmont, and frankly, if there is an error that occurred here, it occurred when Mr. Garmont decided, wrongly as it turns out, through hindsight, to discharge Mr. Alexander and hire someone else. Mr. Alexander had a perfect opportunity to do everything that he told the client that he could do. He knew where the complainants were, had the address in Maryland, knew exactly what they were doing. It was going to be difficult for the state to get them here. The high-low arrangement was worked out between $3,000 and $7,000. He had a strategy. He tried to fulfill that strategy. Mr. Garmont decided not to allow him to complete that strategy. If the court has any questions, I'd be glad to answer them. If not, we'd ask that the court affirm the lower court's decision.
Thank you, counsel.
Mr. Cushman?
Yes, sir.
If counsel, instead of saying, I've never heard of this claim of right defense, it said, look, you may have this claim of right defense, but no jury's going to buy it. You going on the property and taking property because rent was owed, not even telling the tenant about it. If the first attorney had said that instead, would we even be here?
I don't know that it would be the same circumstances. The problem is that Garmont wasn't advised as to the existence of a defense.
But if the trial judge believed that he had been, that even if he had been advised of this defense, that it was an unviable defense and would have made no difference in the outcome, what does that do to your case?
I don't think it does anything, Your Honor. It's not the court's decision. It's Garmont's decision, and he can't make a decision.
So the second prong of Strickland is prejudice, correct?
Right. And
so does defense counsel have an obligation to to tell client of any theoretical defense, no matter how viable or how inapplicable it may be to a particular case?
Yes, sir, I think he does. One of the cases I cited, I believe it's Thomas out of the first DCA, talks about an intoxication defense, reversed a 3850, talking about he wasn't told of an intoxication defense.
Were there facts in that case that the defendant was intoxicated?
Frankly, the case didn't say.
Okay.
It was a 3850, and it talked about he wasn't told, and because Garmont wasn't told, that is the client's decision, and it's the lawyer's job to advise the client about what the law is, and then, of course, what you think is the prospects of winning. But in this case, the lawyer didn't even know there was such a defense and said so.
The way you characterize the ineffectiveness in the summary of your argument in the brief is that the lawyer never recognized Garmont's claim of right to the property on his land, even though he was owed back rent.
Correct.
What claim of right is there to the property simply because you are owed back rent if you don't give notice, for example, if you don't seek court assistance, etc.?
Well, understand, under the circumstances, Garmont was renting this property for a number of years without even a written contract. He's not a sophisticated individual. But on the other hand, when someone makes an agreement for rent, the agreement clearly states, or reason would say, since it's not written, that the tenant has obligations as well, the obligations to pay the rent. And the alternative to that is a lien on the property the tenant stores there. I mean, it's a claim. It's not a perfected right, but Garmont believed he had a right to take it when he took it. But he explained that to the defense lawyer. The defense lawyer basically didn't know about the defense, didn't advise him about the defense, and that's where the ineffectiveness comes in. There was no acting as a lawyer.
Did your client testify that when he took the property, he thought he had a right to take it because of the unpaid rent?
No, he didn't.
Well, what evidence do we have then to support your last statement?
Well, the fact that Alexander testified that they talked about it. This is the defense lawyer testified that they talked about it and that he knew that Garmont believed that, but he said there was no such defense, there was no such right under Florida law. And since the lawyer didn't know it, he couldn't advise it, and that's where the ineffectiveness came in. Thank you.
Thank you, counsel.